Welcome back, viewers. Here's some important piece of breaking input that we are tracking on Times Now. This is an important observation by the Supreme Court, and all opposition rule states, the non-BJP, non-NDA states must pay heed. The Supreme Court has said that we can't impose timelines on president, governor to act on bills. This is a case that has generated a lot of heat, political heat and debate. Across many states, we've seen a standoff-like situation between the Raj Bhavan and the Secretariat where the Chief Minister sits, between the state government and the governor, so to say, and the court was weighing in on the issue. The Supreme Court has ruled that constitutional courts cannot prescribe timelines for the president or governors while they decide on bills passed by state legislatures. Harish Nair, our legal editor, now joining us live for more on this. Harish, there has been a lot of, back and forth between the governors and the state governments on this. Now, this is what the Supreme Court has said today, that we can't give them a timeline.
Yes, that's right, Pranesh. In fact, in a way, it's a win for the president, the governors, and the center, which had filed a presidential reference questioning the timelines, deadlines set for the president and the governors as far as granting, refusing or withholding bills passed by the state assemblies is concerned. We have to tell our viewers one very important thing. Pranesh, when this matter came up for hearing, some opposition rule states like Kerala, West Bengal and Karnataka had filed intervention petitions saying that this reference should not be accepted because all the 14 questions posed by the president had been answered in the Tamil Nadu judgment of April, where timelines were fixed. But from the judgment today, it's very clear that the larger bench, the 5-judge bench led by the Chief Justice, felt otherwise. The Supreme Court has very clearly said that setting a time frame, a timeline, or deadline for the president or the governor is aligned to our constitutional principles. Yes, the president, the governor cannot sit together for an indefinite time on a particular bill. They have to decide within a reasonable time, but no time frame can be fixed. And this is against the principle of constitution, federalism, and the separation of powers. And one more very important observation made by the this particular bench, 5-judge bench, is that, Pranesh, if the governor does not act within a prescribed time limit, it cannot be deemed assent, cannot be given. That also has been struck down by this 5-judge bench, saying that another constitutional authority cannot whittle down the power of another constitutional authority. So the Supreme Court very clearly saying that upholding most of the argument put forth by the center, that the Supreme Court cannot legislate, like saying that because under Article 201.
Right, Harish, just hold your thoughts. Mr. Hitesh Jain needs no introduction. Senior advocate, was member of the Law Commission, joining us on the phone line. Good afternoon, sir. What do you make of the Supreme Court observation?
Well, the Supreme Court's unanimous opinion on the presidential reference is a resounding reaffirmation of the constitutional architecture governing the governor's assent. Basically, the court has spoken in one voice, and the message was loud and clear by the court that the judicial review cannot be converted into judicial governance. And secondly, I had already voiced my view when the earlier Supreme Court judgment had come in the month of April, and I had highlighted my views, and I had written also quite vividly. When you prescribe rigid timelines for the governors or the presidents, it would amount to judicial legislation rather than interpretation.
Right, but Mr. Jain, do you think the people in at least opposition rule states will see merit in what the Supreme Court has said and will take it in the right spirit?
I think they should take it in the right spirit, because verdict today restores the stability in the center-state relation, and it also reinforces the constitutional morality for the holders of the high offices. And basically, the Supreme Court has also basically sent a message that judicial review remains review and not administration. I think this is also one of the very important points the Supreme Court has sent the message.
I remember reading your piece in the Indian Express, if I'm not wrong, where you had said that, this would amount to judicial legislation rather than interpretation. Hitesh Jain, thank you for joining us and putting that in context for our viewers. Harish, thanks for that update.